Good day, good people. If you're at all interested or involved in a lawsuit that accuses people of organized racketeering, otherwise known as RICO, you need to pay attention to the new rulings that are coming down in active civil RICO lawsuits, such as the ruling that was just handed down in Jones versus Combs, otherwise known as Diddy, where a judge just threw out all the civil RICO allegations against Diddy and, in a very rare and shocking move, admonished the plaintiff's lawyer for his incompetent and unprofessional conduct. So the first part of this video is an update on Jones versus Combs, the explosive lawsuit that was filed by a producer just before Diddy's homes were raided by the feds. And the last part of this video is for those of you who are following the civil RICO lawsuit filed by the father of Sebastian Rogers and the band of convicted frauds and felons that claim to be the victims of racketeering YouTubers. So the headline on the Diddy civil RICO ruling is this: the judge has thrown out the RICO claims made against Diddy and his associates by plaintiff Jones, but has allowed the SA claims to go forward. What you're seeing on the screen is the court's conclusion. The court is answering the defendant's motion to dismiss the lawsuit. That's why the conclusion reads like it does. It says the motion by defendants is granted in part and denied in part. The primary reason the RICO claims have been denied is because the plaintiff failed to show that the harm that was done to him resulted from RICO-related predicate acts. It says here, to show RICO, a plaintiff must show that the damage to its business or property resulted from the alleged predicate acts constituting the RICO violation in this case. In its summary paragraph throwing out the RICO, the court makes a very interesting statement that will come into play when we talk about the YouTube RICO lawsuit. It says, in sum, whether or not Jones has adequately alleged the existence of a RICO enterprise. So basically, the court is saying, hey, the RICO enterprise may exist, but Jones doesn't have claims against it, okay? It goes on to say, he has not tied the activities of that enterprise to defendant's breach of contract or any other business or property harm incurred by Jones. It also bears reiterating that Jones fails to address any of these arguments in his opposition brief. And while the court prefers to decide issues on the merits, it should not be necessary to root around a 402 paragraph complaint to contrive novel arguments on Jones's behalf. So the court's basically saying, we're not going to do your work for you. It goes on to say, this court may and generally will deem a claim abandoned when a plaintiff fails to respond to a defendant's arguments that the claim should be dismissed. So the court is saying that there are all kinds of claims in the defendant's motion that the plaintiff didn't answer to. So the court's saying, okay, we're dismissing those claims because you didn't give a valid argument. Where else are we seeing this? And further it says, Jones' effort to convert a garden variety breach of contract case into a RICO suit therefore fails, and his RICO claims are dismissed as to the Combs defendants and quorum. You see, Jones claimed that all the sex acts that he was coerced into were tied to the larger criminal enterprise that Diddy was conducting and now is being held in jail for his trial in May. But the judge is saying, we see a reason to move forward with your individual claims against Diddy, but for this to be tied to a larger racketeering enterprise, you need to lay down the predicate acts, and they're not here. So it's honestly pretty shocking, right? You would think that if a guy is being held in jail pending trial for RICO against the government, a judge in a civil lawsuit would also see fit to try him for those claims against someone who worked for and lived with him. But that one portion of the RICO law, which requires predicate acts to be asserted, are not there. And so the RICO portion has been thrown out. Another shocking part of this ruling is a section called Warning to Counsel. Here are some of the portions of that section. The court finds much of Blackburn is the attorney, much of Blackburn's conduct regarding defendant's motion to dismiss to be unsettling. Blackburn's filings are replete with inaccurate statements of law. Pay attention to that. Inaccurate statements of law, conclusory accusations, and inappropriate ad hominem attacks on opposing counsel. And then it goes on to show examples. And then it continues to say, the court has inherent authority to sanction Blackburn should he act in bad faith, vexatiously, wantonly, or for oppressive reasons. It warns Blackburn that further misconduct may lead to sanctions or to referral for discipline. Blackburn has a professional obligation both to the court and to his client to state the law accurately, to collaborate in a respectful and constructive manner with fellow lawyers, and to allow this litigation to proceed efficiently. Now, I've been dealing with and reporting on court cases for many, many years, and it is highly unusual for a judge to include an entire section admonishing a plaintiff's attorney for being incompetent and unprofessional, and also warning that he could see sanctions if he continues in that manner. But interestingly, the judge is not penalizing the plaintiff and is allowing the lawsuit to move forward based on SA allegations, which says, hey, I think these claims have merit. It's just that the lawyer is acting unprofessionally. Now, Diddy is scheduled to go to trial for his criminal RICO charges on May 5th in New York. It will be very interesting to see if this decision has any impact on that trial. The ruling in Jones versus Combs does note that they've made the decision regardless of whether Diddy is running a RICO organization. They're saying that even if Diddy is running a RICO, Jones's claims do not meet the statutory requirements for a RICO case. So this brings us to the section of the video where we talk about what this means for the RICO lawsuit filed by Seth Rogers, Dog the Bounty Hunter, Nick the Hat, Hong Z, Bullhorn Betty, Brittany J, Tony Mathis, and a few others. If these plaintiffs have not paid attention to rulings in other civil RICO lawsuits, they should, because whether they like it or not, that is how the courts work. Especially in states like Pennsylvania, where the RICO law is brand new. You see, courts make their ruling decisions based on a thing called precedent. And when their own state doesn't have a precedent-setting case, they adopt precedents from federal cases or from other states, especially from states where courts have very active dockets and they're in the nearby region, like the state of New York. I can almost guarantee that the YouTube RICO judge will see the decision in Jones versus Combs. And if I were the plaintiffs in the YouTube RICO case, here are the 3 things about this Diddy ruling that would freak me out. First, that the RICO was thrown out because Jones could not cite predicate acts. Second, that the ruling makes it very, very clear that you can't just throw a bunch of pages at the court and expect them to make your case for you. And third, that the ruling takes the time to strongly warn and admonish the plaintiff's attorney for his incompetence and unprofessionalism. So let me expound on these 3 things, starting with the predicate acts. What are predicate acts? You're looking at the Pennsylvania RICO statute, which cites the underlying pattern of organized predicate acts necessary to make a RICO claim. Read through these. I'm not going to read through all of them myself. But there's criminal homicide, terroristic threats, kidnapping, human trafficking, arson, blah, 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 right? Now you're looking at paragraphs 42 through 46 of the amended RICO complaint filed by the plaintiffs in the YouTube lawsuit. As you will see here, paragraph 42 cites the very statute I just showed you. But when you bounce down to paragraph 45, the plaintiffs list a completely different set of predicate acts than are listed in the law. This is why it's so important to talk about incompetence in legal filings and to remember that the judge just admonished lawyer Blackburn for misstating the law in his filings. Now look again. Here are the predicate acts in the actual statute, and here are the predicate acts listed by the plaintiffs. Do they match? No. But let's entertain this blatant misstatement of law for a second and say that the law hasn't been updated to yet include harassment and cyberstalking. Do you really think that a judge in Pennsylvania is going to feel any differently than a judge in New York about needing to root around a lengthy complaint to form their argument for them, especially after they've swarmed the court with thousands and thousands and thousands of exhibits that on their face do not constitute predicate RICO acts? Hell no. So the plaintiff should be freaked out about this ruling on predicate acts. They should be even more freaked out when they see a judge in New York say, hey, I'm not going to make your arguments for you, and we don't like it when you sit there and misstate the law in your legal filings. And they should also be very freaked out when they see that a judge in New York has noticed the utter incompetence of a lawyer to the point of putting an entire section in a ruling with a warning. Do you think that the Pennsylvania judge has not noticed the insane level of incompetence that has been displayed in the midst of this RICO case? Like naming a lawyer in the initial complaint who is not involved, or failing to respond in time to several motions, or standing in front of the judge in an anti-SLAPP hearing and trying to claim that one of the defendants hasn't been served yet, even though proof of service has been docketed, or trying to enter exhibits into evidence out of turn, or that the lawyer has submitted an emergency request for a gag order in the midst of waiting for a ruling on whether the entire lawsuit itself is a gag on people's freedom of speech. And the worst of all, that a practicing lawyer has completely misstated the law in his own legal documents. Come on, man. Listen, Green Team, whenever you're challenged about the merit of this lawsuit, you go back to complaining about things that were said or done by this defendant or that defendant about one plaintiff or another. The problem is, this is not a harassment or defamation lawsuit. This is a RICO lawsuit, and harassment and defamation are not RICO predicates. That is why you have completely lost me in this fight. As I've said in various chats, if the judge rules in favor of the plaintiffs in this case and says that their claims of organized racketeering are valid, I will eat an entire jar of olives. And I hate olives. Thank you for watching. Please hit the like, subscribe if you haven't already, and peace out.